My name is Shazia Khan. Today's session is on legal methods, and we're looking at learning outcome 1, which is to understand the sources of law in the UK. Okay, we're gonna the unit aim, the aim of the session and the unit aim is to equip the learner with the knowledge and understanding of identification, interpretation and analysis of legal sources and materials. The acquired skills will enable the learner to apply the law to the facts of the problems in any given legal area and to communicate clearly and persuasively and to reach a satisfactory solution to legal disputes. Learners will explore fundamental principles and components of English legal system, the judiciary, the civil and criminal process, and will gain an appreciation of how the main principles underpin all the substantive and procedural areas of law. So we're going to first go on to look at how to fully cite cases. Now, sometimes people struggle with citing cases. When you look at civil cases, you have a case, and this is a case example for you. You've got Davies and Johnson, 1979 to WLR 553, and this was pronounced Davies and Johnson, not Davis against Johnson or Davis versus Johnson. Okay, so the first bit of it is it will be Davis is the name of the plaintiff, the claimant, sorry, he could be the plaintiff as well. Then you have Johnson, who is the name of the defendant, and then 1979 is the case, the case was reported, and then number 2 is the volume number, and then WLR is weekly law reports. So it could be monthly law reports, it could be, you know, quarterly law reports. So you might say QLR, it depends. Okay, and then 553 could be the first page of the case report. Okay. This is how you fully cite cases. Now, if you're talking about this in the assignment, you will need to fully cite cases like that, okay? Or any assignment, anything you do in law, this is really important to use because it identifies how you fully cite cases. In cases, we've got R against James, 2006, EWCA Crim 14. So R and James, who's R? Which we're going to go through a little bit later, who R is. Okay. R is the queen, okay, or Regina. Now, in this instance, the king, okay? So it's the king against the individual in criminal cases. So the year of the case will be 2006. And the EWCA stands for England and Wales Court of Appeal. Okay. The CRIM stands for the Criminal Division of the Court of Appeal. Civil divisions will be CIV, okay? And the case number assigned by the court is number 14. So this is in criminal cases. The law report series, there are a number of different series of law reports which are available. The Incorporated Council of Law Reporting, which is ICLR, publishes the official law reports, including appeal cases, which is referred to AC, Queen's Bench, QB, Family, which is FAM, and Chancery Division, which is CH. There is a hierarchy of law reports, and the official law reports are considered the most authoritative or best reports. And on the side are all the law reports that could be there, and you could see these in, you know, when you see a case, for example, you could see this in a case citation. So if we go back to that case there, it said the division was Crim division. So if you go back to here, it'll identify the divisions there, Crim Appeal Division. So it tells you where the reports are coming from. It tells you where the appeal cases are and the law reports are coming from. And it is really, really helpful when you're citing cases. When we look at statutes, okay, when you look at statutes, what is a statute?
Statute, I don't really know.
Okay, statute is a law, okay? Statute is referred to as a law. So you could have the criminal, you know, the Human Rights Act. Is that a law?
The Human Rights Act?
Yeah, it's a law, isn't it?
Yeah.
Yeah. So these are examples of statute. Okay. So to cite an act of parliament, use its short title and date. For example, the Human Rights Act 1998. To refer to a particular section in the act, you use S for section or SS for sections, part or schedule and paragraph within a section. Okay, so you've got the Human Rights Act, section 19, paragraph 1B. So the first bit of it is the title of the act. Okay, so you could have the Equality Act, you could have the Sexual Discrimination Act. They are all acts that have been passed through Parliament because there's a need for them acts. Okay, then you've got maybe the abbreviation, which is section S. Then you've got the section number 19. Then the subsection. So within 19, there could be subsection 1, 2, 3, 4, 5, but you've put subsection 1, and then the paragraph within the subsection is 1. It's really, really easy to kind of go through this and identify it, you know, later on when you do that extra reading. It's really easy to identify it, but these are the ways that you'd identify it. So you'd have the act first, the year, the abbreviation of the section would be section S, then 19, subsection 1, and then paragraph B, and that's in an act. Okay.
All right.
So key judicial offices in England legal system. So we've got the President of the United Kingdom Supreme Court, PSC, head of the Final Court of Appeal in the UK, Lord Chief Justice, which is referred to as CJ. And in some cases, you'll see this. If you're looking at a case, it'll say CJ, Lord Justice, Lord Chief Justice identified this or stated this, and then it'll go on. Okay. And head of judiciary and president of the courts of England and Wales. We've got the head of the criminal division of the Court of Appeal, who's responsible for training, guidance, and deployment of judges. He represents the views of the judiciary to the ministers. Then we've got the Master of the Rolls, MR, who's the head of the civil division of the Court of Appeal and head of the civil division. Heads of division, so you have the Chancellor, who's the head of the Chancery Division of the High Court. The President of the Queen's Bench Division, PQBD, head of Queen's Bench Division of the High Court, and President of the Family Division and head of Family Justice, head of Family Division. Why do you think we've got, you know, separate heads of division?
Sorry?
Why do you think we've got, you know, like the heads of division? We've got the Chancellor, the President of the Queen's Bench, then the President of Family Division. Why do you think Family Division is separate? Do you think do you think there's a need for having separate divisions?
Yes, to deal with different legal cases.
Yes, excellent. Yes, to do with different legal cases, there's a need to have this. Okay,
Yeah.
and there's a need to have it because every case is individual, isn't it?
Yeah.
So there's need to have all these divisions. Then we've got Lord Chancellor. Prior to the Constitutional Reform Act 2005, the Lord Chancellor was both the head of the judiciary and a member of the governments. Since 2005, the Lord Chancellor is the Minister for Justice in the Ministry of Justice. He has no judicial role, and his previous powers have been transferred to the Lord Chief Justice, who is now the head of the judiciary. The Lord Chancellor retains power over judicial appointments, although the selection of judges is made by Independent Judicial Appointments Commission. The Attorney General, AG, this is a political appointment. The Attorney General is a legal advisor to the government. He appears in court for the Crown in important cases, and the Attorney General has the power to refer points of law to the Court of Appeal in relation to acquittals in criminal cases and against unduly lenient sentences. So we have the Solicitor General, who's the Deputy for Attorney General. And then we have the Director of Public Prosecution, DPP, who's the head of the Independent Crown Prosecution Service. Now, the Crown Prosecution Service works for the Crown. Okay, so they prosecute people. And then you have solicitors who work for the plaintiff or the claimant, okay?
Okay.
So self-assessment questions. What we're going to do is these questions is asking you a little bit about your self-assessment. But what I want you to do is I want you to do this for next week as your homework. Is that okay?
Okay.
Yeah. So these questions, number 9 is I want you to just try and we'll go through these next week, but I want you to do them for next week as homework. Okay.
Okay. Okay.
So some key terminology that may be important if you know, obviously, you know, if you don't understand the law in the UK are, what are the sources of law? So the sources of law are the origins of law, the binding rules that enable any state to govern its territory. The term source of law may sometimes refer to the sovereign or to the seat of power from the law derives its validity. The sovereign is the queen, now is the king, okay? That's the sovereign.
Okay.
Primary source of law are legislation, which are acts of parliaments or statutes, statutory instruments, orders in council, and these are passed through parliament, okay? They have this thing called delegated legislation, and all the laws are passed through the House of Commons, the House of Lords, and then through parliament to make the final decision, okay? Whether the law can get passed. Then we have case law, and decisions of higher courts or courts of records which are binding on and must be followed and applied by less senior judges. Why do you think case law is very important?
Because
Judges, sorry, go on. Sorry. What were you saying, Jacqueline?
no, I wanted to say that case laws are important because they judicial decisions that
Yes.
that could be referred to.
Yeah.
For,
Judges will refer to them, won't they? If judges think that there's a similar case, judges would refer to that.
okay.
And that's case law. Then we have secondary sources of law, which are textbooks and commentaries by legal writers, so academics, the opinions of legal experts and decisions of the court of whatever seniority of foreign jurisdiction. So these are secondary sources of law. We have the English legal system in the UK, which is the most important. That's what we follow, and the main jurisdiction in the UK. So the UK is divided into 3 jurisdictions or self-contained legal system. We have England and Wales, Scotland and Northern Ireland. Each jurisdiction has its own laws. It has its own court system, lawyers and judges. However, laws that apply in one jurisdiction, particularly if they are derived from legislation, which are acts of parliament and statutory instruments, may apply equally or very similarly in other jurisdictions. While the courts in each jurisdiction can decide cases differently from those in other jurisdictions, the final appeal for all of them goes to the UK Supreme Court. And that's the head, that's the top court is the UK Supreme Court. And it's the last court, okay? Common law and statute. Common law is the law declared by judges. It derived from customs and precedent. It originated with the legal reforms of King Henry II in the 12th century and was called common because it applied equally across the whole country. The doctrine of binding precedent, whereby courts follow and apply the principle declared in previous cases decided by more senior courts known as the courts of record, is also known by the Latin expression which is called stare decisis. The common law includes both substantive rules such as the offence of murder and procedural ones such as the court procedure rules derived from the inherent jurisdiction of the court. Common law rules may be superseded or replaced by legislation which is said to trump or to take precedent over the common law. There is a limit to the extent to which common law judges, however creative or activist, can reform an out-of-date law, particularly if it derives from a statute. In such circumstances, only Parliament can change the law. The need for such often follows a period of research and consultation by the Law Commission, which was set up to review and propose reform to old or inadequate laws. Then we've got common law and equity. The common law was historically administered in the King's Court, so it developed over the King's Court, and equity developed as a separate system of mainly discretionary remedies administered by the Lord Chancellor, often as a way of ameliorating the justice done by inflexible rules of common law. So because there was not enough remedies in common law, equity needed to be introduced, okay? And equity brought in new remedies. Equitable concepts such as trusts are now generally dealt with as part of the business of the Chancery Division in the High Court, but since the Judicature Act 1873 and 75, when the systems of law and equity were fused, they will no longer be treated as separate jurisdictions, and both legal and equitable remedies can be provided in the law. So at one time, you know, in common law, because there wasn't enough remedies, equity had to be brought in. Equity wasn't there to replace common law, it was just there to help and bring in these remedies, okay?
Okay.
Then we've got the civil law. Civil law may be defined in the opposition to three alternatives. Civil as opposed to criminal, civil in the sense of secular law as opposed to electoral, I can never say that, or other forms of religious law. Civil law as a legal-based system based on the code of law, such as Code of Napoleon, developed in France, as opposed to the common law system based on the doctrine. The meaning thus depends on the context. A criminal case may be decided in a civil court if the court is a secular rather than a religious one, or is the court of continental legal system, such as that of France. But a civil court in the first sense, such as the Chancery Division of the High Court, is not going to hold a murder trial. Instead, such a case will be heard in a criminal court like the Crown Court. Some types of civil law. So contract law. The law of contract is concerned with the formation and interpretation or construction of written or oral agreements between companies or individuals. A contract does not have to be written down to be a binding contract. So, you know, verbal can be a contract as well.
Yeah.
Disputes over contracts may concern whether or not a contract ever came into existence, what its various terms and conditions actually meant, whether one party has broken, so they've breached the contract, and if so, what remedies, such as remedies as injunction or specific performance, can be ordered. So the law of tort. Tort law is a legal wrong. A claim based on tort usually requires the claimant to establish that the defendant owed a duty of care and they broke that duty. For example, you know, like in negligence cases, you know, you as a doctor have a duty of care to your patient, don't you?
Yeah, yeah.
If you break that duty, you have, you know, broken your duty of care. And then there's a claim there for negligence. Classic types of claim in tort are those based on negligence, nuisance, defamation, misuse of private information, etc. Sometimes a claim may involve both contract and tort, but a claim based in tort does not require there to be a contract between the parties, simply the one of them owed the other one a duty. Such a duty may have been developed either at common law or under statute. So for tort cases, you know, you don't need to have a contract. You know, again, we use the example of the doctor and the patient. They have a duty of care. They don't need to be in a contract, okay? They have that duty of care. If you go to a doctor's or if you are admitted to hospital, straight away they have a duty of care which they have broken if they negligently do an operation and maybe leave something inside your body or something like that, or they haven't done the operation properly. That's negligence. Company law. This is concerned with the formation and regulation of companies and corporations, which are separate legal persons from the individuals who own them, usually by acquiring shares in the capital value of the company, known as members, and those who manage and direct activities known as directors. When a company's debts exceed its income and the capital, it becomes insolvent. So that means, you know, they become bankrupt, they don't have any money, and may be put into administration or eventually wound up altogether. There may be claims by different classes of creditors, and regulatory proceedings may be taken against the directors. Company law covers all these matters. So for example, if you open a company, Jacqueline, and you have so much debt in that company, and you can't pay your creditors, then you will become insolvent and you will declare bankruptcy. Okay. When you declare bankruptcy, there will be proceedings against you to get the money against the directors, so that you can pay the creditors.
Okay.
This is quite a popular thing, you know, in some businesses that don't work, you know, smaller businesses or maybe large businesses that don't work. And because of COVID, you know, maybe a lot of businesses at that time became insolvent, you know, and couldn't carry on because of the issue around COVID. Revenue law. This deals with disputes over the assessment of taxes and duties levied on organizations and individuals by the government. Types of tax include income tax, corporation tax, capital gains tax, inheritance tax, VAT, and all are covered. Revenue law is so called after the Inland Revenue Department, now merged with Customs and Excise, and it was responsible for levying such duties as import duty, excise duty to Her Majesty's Revenue and Customs HMRC. Intellectual property. And this intellectual property law is often is concerned with rights and duties relating to things like patents, designs, copyright and trademarks. Things like you can't copyright, you know, or you can't do the same trademark or any sort of inventions. Patents protect scientific inventions which often have an industrial or commercial value. Design rights protect the commercial value of a product's design. Copyright is concerned with the artistic works, whether written, composed, or created in some other artistic way. Thus, a painting or illustration would generally be protected by copyright rather than a design right. Why do you think people protect their work?
Just not to be copied or something like that. Just not to be copied. Idea of the business or something.
Yeah, not to be copied, and to protect their work that they've done and not to be stolen by someone else.
Yeah.
Trademarks protect the identity and reputation of businesses. Claims for passing off, where a business passes itself or its products off as being those of another business, are also considered part of intellectual property law. Some intellectual property law rights have to be registered before they can be enforced, but others do not. Disputes may arise over whether a person was entitled to register the right and whether such a registration was valid. So this is really important in regards to, you know, what you produce. So you've done an invention, you've created something quite good, and then you don't want anyone to take that invention or copy that invention or steal that invention. So you have to, have to go through copyright and register that invention as yours, because there have been people out there that have been, copying inventions and pinching inventions and try to, pass them off as their own invention. So, as an artist or as someone who's invented something, you have to protect your own product design. We've got media communications law. Media law deals with disputes over the regulation of and the content published or broadcast by media organizations and individuals such as journalists who generate that content. Information law is concerned with rights such as freedom of information and duties such as data protection relating to information. Communications laws include telecommunications, the internet, the social media, though there's considerable overlap with media and information law. They are among the types of businesses dealt with by the Media and Communications list in the Queen's Bench Division. Family law and the Court of Protection. Family law is concerned with marriage and divorce, children and parental matrimonial finance. Some issues involving children are described as private law cases because they only involve private individuals, usually the parents or the guardians. But other disputes such as care proceedings involving the local authority and other parties are described as public law cases. Cases involving children may relate to medical treatment for which, by the virtue of their age or lack of capacity, they are unable to provide consent. Similar cases involving adults lacking capacity, so that could be adults that, you know, have any sort of mental capacity or are of unsound mind, are dealt with by the Court of Protection, which also deals with administrative issues such as where an adult lacking capacity should live and decisions about their financial affairs. So this could be things like, you know, if the person is disabled or of unsound mind, or the person has any sort of special needs, they would be able to, the Court of Protection would be able to help them because they don't know how to, you know, they don't have the capacity to make decisions about anything to do with their finances or anything to do with where they live. So the Court of Protection will help them. It's sometimes very difficult for a person who has special needs or has any sort of mental, is of unsound mind, to understand what's going on. So, you know, we must be able to, you know, provide for these people as well, you know, rather than, you know, not everyone is the same. So, you know, we must be able to provide for people with special needs and things. So we've got 1.1. We distinguish between primary, secondary and delegated legislation. So primary legislation, as we said earlier, consists of acts of Parliament or statute. Secondary legislation, also called delegated legislation, is the granting of additional law-making powers to another branch of government by an act or statute. In contract law and administrative law, delegation, which is the Latin phrase is intercio, is the act of giving another person the responsibility of carrying out the performance agreed in a contract. The function of delegated legislation, sorry, there are three types of delegated legislation. These are orders in council, statutory instruments and bylaws. The function of delegated legislation is to allow the government to amend a law without having to wait for a new act of Parliament to be passed. Further, delegated legislation can be used to make technical changes to the law, such as altering sanctions under a given statute. Delegated, also known as subordinate legislation, is legislation made not directly by Act of Parliament, but under the authority of an Act of Parliament. Parliament has regularly and extensively delegated to the executive government limited power to make certain regulations. So anything that needs to be added to an act, anything that needs to be amended would have to go through the process of delegated legislation. Types of legislation. So primary legislation, this is legislation contained, as we said earlier, in an Act of Parliament. You could have a public bills, include private bills and private bills. Scotland, Wales and Northern Ireland also passed primary legislation. And then you've got secondary legislation, which is also subordinate or delegated legislation, which is legislation delegated to ministers by an act. Only small amount is considered by Parliament, such as regulations, orders in council, statutory instruments, and statutory codes of guidance. So primary legislation, the law that is made by an Act of Parliament, usually embodies the policy of the government. A bill is usually introduced by a minister, and it can be introduced into the Commons or the Lords, but must be passed by both parties. Note that primary legislation is also passed by Scottish Parliament and Northern Ireland and Welsh assemblies. Government bills dominate the business of Parliament. Bills are introduced by ministers who pilot it through the parliamentary stages in Commons and Lords. Opposition will indicate whether they oppose the bill at second reading, which is a reasoned amendment. Secondary legislation. So secondary, also called subordinate legislation, is all other forms of legislation that are not acts of parliament. It is very similar to the administrative law in the United States. The legislative branch of government often delegates power to allow ministers to make secondary legislation. Secondary legislation also includes directives, regulations, and decisions by commissions or councils. Most acts of parliament in the UK contain provisions to allow secondary legislation. The two types of secondary legislation are delegated legislation and prerogative legislation. Delegated legislation allows other branches of a government to make changes to a law as they become necessary. There's no need to start a new bill in Parliament. Prerogative legislation are those powers given to certain officials to create laws and rules and regulations. Do you think that when we go through primary and secondary legislation and the laws are being changed, do you think there's a need for the laws to be changed all the time?
Yes, of course. There's the need to.
Why do you think that?
Yeah, because with time, you need to change. Yeah, with time, the different cases, people change, culture changes. So of course, there's the need to.
And society changes, doesn't it? Society changes, and there's a need for, you know, societal change all the time.
Yeah.
So, you know, when society changes, you know, you will want new laws to come into place. For example, you know, driving without a mobile phone, because everyone is driving with a mobile phone in their hand. The law needs to come into place that if you drive with a mobile phone, you will get 3 points or 6 points and a fine.
Wow, okay. I didn't know that.
Yeah, in the UK, yes, you do. You get a fine and points in the UK, yes, driving with the mobile phone. So these laws, there's a need for these laws. Also, you know, driving your car with the flip-flops, you know, slippers. You're not allowed to drive with slippers.
No.
No, not in the UK. You know, you get a fine. You get points for that as well. So yeah, there's maybe are you in Italy? Yeah.
Yeah, I'm in Italy.
Yeah, maybe the law is different there. For every jurisdiction, the law is different. But here, if you drive with, you know, flip-flops, you know, like beach sandals and things like that, you're not allowed to drive with that. You're not allowed to drive with mobile phones. And there's lots of new laws that come in all the time.
Wow.
And the laws that come in is to prevent, you know, what's not working, you know, and people are not, you know, they're not following the law, so there have to be changes made to follow the law.
Okay.
And then we've got 1.2, which is explain the hierarchy within statutory sources and the case law. So what is statutory source? Statutory law or statute law is a written law passed by a body of legislature. Statutes originate with national, state legislatures or local municipalities. What are the 4 types of law? So we've got legislation, common law, European law, and the European Convention on Human Rights. So we've got that diagram, the hierarchy of laws. We've got constitution, statute law, statute and legislation, regulations and procedures, and codes of conduct. The hierarchy of laws, and this is a snapshot of what the hierarchies of laws is. Firstly, we've got constitution, which is establishes the innate characteristics of the country and its sovereignty, outlines the rights and responsibilities of its citizens. As such, it is supreme law. It establishes the country's governance structure, and all other laws must adhere to the Constitution. The Constitution should reflect and adhere to the country's international obligations. So, you know, we must follow what the country wants us to do, the rights and responsibilities as citizens. And then you've got international laws, which is trans-border agreements that have different impacts on the country's law, depending on the treaty language and the way a country's constitution managed them. Yes. Sometimes only a limited degree of compliance with treaties, and some treaties that enshrine fundamental rights are not always followed through in the signatory nations' constitution or through domestic enforcement. There's no legal way to enforce compliance unless the treaty sets up a dispute resolution process. Then we have statutes and legislation, and statutes are enacted by the legislative branch of the government and govern a wide range of issues that require regulation. In a modern democratic state, including elections, they must adhere to the Constitution and international law, and they must be amended by the same process as first enacted and enforced by a country's enforcement agency. Again, we've got common law and case law. Common law is law made by the courts, not legislature, and is not a level of hierarchy per se. It consists of the judgment of courts to interpret the wording of statute law, to protect the principles of natural justice, to fill in the gap in the law, or to deal with an unforeseen situation not covered by statute. Judgment of a court may award damages, punishment, sanction, or other remedial action enforced by a country's enforcement agencies. Regulations is the next one, which is a form of delegated legislation developed and enacted by ministers, department heads, or by an independent body or commission to administer their responsibilities. They must adhere to the Constitution, international law, and the governing statute, and can be enforced in the same way as statutory law. They provide detail of administration of the principles in the law, and also it is a violation of regulation can be treated as an offence and enforced as such. Procedure. So a procedure is a description of the required steps necessary to complete a process. Procedure are generally written by an administrative body to ensure that the law and regulations are applied consistently and fairly to all the parties. Enforcement of the procedure is generally achieved by requested compliance as a condition of completing a process of receiving a benefit, for example, candidacy, rather than sanction or punishment. Codes of conduct and guidelines. So codes of conduct are a written set of rules, principles, or standards to govern the behaviour of certain groups. It is the best practice for EMBs to develop codes of practice, codes of conduct to govern external actors such as candidates, media, election observers, security personnel, and election officials. Enforcement of codes of conduct depends on whether they are considered soft or hard laws. Codes of conduct are considered soft law when they are not passed by lawmaking body and thus relying on voluntary compliance. So codes of conduct must be followed. So you have, you know, the regulations and the standards that must be followed to adhere to, you know, everything in regards to any sort of standards. Guidelines, instructions, policies. So terms such as guidelines and instructions are uncertain in meaning and can result in ambiguity, particularly with regard to enforceability. Policies are broad, informative statements of intent regarding principles to be followed, priority of programs. These should not be used as they were elements of structure of the hierarchy of laws. Now we've got the hierarchical structure of the courts and the importance of the hierarchical structure in regards to the UK courts. Okay, so we've got the first court, so we'll start at the bottom, we'll start at the top. Actually, no, we'll start at the bottom, it's better. It shows you how it goes. So the number of tribunals outside the structure of the courts as well, for example, school exclusion panels. At the bottom, we've got the magistrates court, which is the lowest court and trial, and this is trial for most criminal offences, some civil matters. And in the magistrates court are, you know, like insurance offences, car offences, mine. The magistrates. The county court is a trial for most civil cases, so not criminal cases. And then you have the family court for most family cases, and that's private because there's children involved and things like that, so it's very delicate. So they're family court. Then if something can't be tried at the magistrates court, it will go to the Crown Court. Okay. That's just for indictable and some either criminal offences, and that could be things like murder or rape or anything like that. Then there's the High Court, which is the Chancery, Queen's Bench and family divisions, and they will hear the appeal. So they will hear the appeals from the Crown Court or the Magistrates Court or when any of the other courts. Then we've got, if it's not dealt at the High Court, it goes to the Court of Appeal. And in the Court of Appeal, you have the appeal only. So it's only on points of law to either criminal or civil division. And then it'll go to the UK appeal, Supreme Court, which is in London, which is the appeal only. So they will only look at the points of law. They won't look at any other evidence. Then you've got on the other side, you've got the Employment Tribunal appeal, and that deals with employment tribunal cases. If there's any sort of discrimination or any sort of, that's the appeals one. Then the Employment Tribunal, England, Wales and Scotland, and that's any sort of matters regarding any sort of claims for employment. The Upper Tribunal deals with appeals, and the first tier of tribunal deals with appeals from executive. So this structure is the most highest court is the Supreme Court, and they need to be dealt with in regards to, you know, if something is not being dealt with properly at the lower stage. So stages in English lawmaking. So we've got a bill. A bill can be introduced by the government or an MP. Initial proposals are set out on a green paper. So that's the first stage, and the green paper for discussion. After feedback, a white paper is presented to the House. The second one, the second bit is the first reading. This first reading is brief and is just an introduction. The document is printed and circulated to all members. Then we have the second reading, which is part 3. And this is, the second reading is the most important, as it's the first opportunity to debate its content. So there's a vote at the end, and the bill can be voted out and defeated at this stage. So if, you know, this is if a law, if they feel like the law's not, a law shouldn't be passed, then it will be outed out. But if they feel like they need to go further and the law's good, they will go to the committee stage, which is the 4th stage. The committee stage involves detailed examination of a bill. So a bill is something that will be sent into Parliament and then becomes a law. Do you understand? So we have a bill first and then it becomes a law. It's followed by proposed amendments. Each clause is agreed, modified or removed. Then the report stage, which is number 5, which is once the committee has finished its scrutiny of the bill. So they need to scrutinize it to see if it's a good bill. It reports back to the Houses for another debate of the bill and any amendments. The third reading is the final chance to debate the bill and is restricted to its actual contents rather than what should have been included. There's final vote on the bill, and then it goes to a first reading, second reading, committee stage, report stage, third reading, and then if the bill is voted in after the third reading, it will go through similar stages in other houses. Then the law is passed and it will need royal assent. Royal assent, it needs to be signed by the Queen, but no longer the Queen is in place, it will be the King. Once both parties have approved the bill, the Prime Minister will present it to the monarch, and once he has signed it, the bill becomes an Act of Parliament. So it's quite a lengthy process, but it's a good process to go through. You know, sometimes, you know, it may not be a good law, so they may not pass it. So it needs to go through this process to identify whether it's good to be passed or not. So one point, it's a long process, but it's a good process. 1.3, explain the impact of Human Rights Act. What are human rights? Human rights are the basic rights and freedoms that belong to everyone. Ideas about human rights have evolved over many centuries, but they have achieved strong international support following the Holocaust and World War II. To seek to protect future generations from a repeat of these horrors, the United Nations adopted the Universal Declaration of Human Rights. For the first time, the Universal Declaration set out fundamental rights and freedoms shared by all human beings. What is the European Convention on Human Rights? The European Convention on Human Rights was also drafted after World War II by the Council of Europe. The Council of Europe was set up as a group of like-minded nations. It pledged to defend human rights, parliamentary democracy, and the rule of law, and to make sure that the atrocities and cruelties committed during the World War would not be repeated. The UK had a major role in the design and the drafting of the European Convention on Human Rights and ratified the convention in March 1951. The convention came into force in 1953 September. The convention is made up of a series of articles. Each article is a short statement defining a right or freedom together with the permitted exceptions. For example, Article 3 is the prohibition of torture, that no one shall be subjected to torture or inhumane or degrading treatment or punishment. The rights in the convention apply to everyone in the states that have ratified the convention. So anyone that signed to the convention, these would apply to them. Anyone who believes that a state has violated their human rights should first take every possible step to have their case resolved in that state, including through the courts. If they believe that their violation has not been resolved, they can then go to take the case to the European Court of Human Rights, which was set up by the European Convention on Human Rights and is based in Strasbourg in France. And the whole point of this convention is to protect individual rights. There's 47 countries that have signed to this convention, and they must implement this convention in their country. Okay. So what is the Human Rights Act? The Human Rights Act came into effect in October 2000. The Act enables people in the UK to take cases about their human rights directly to a UK court. So, for example, if you have been arrested by the police in the UK and you feel like your human rights have been breached because when they arrested you, they took you into a cell and beat you up, that is your human rights being breached. Also, another example is if you have your human rights can be breached if you follow your religion. Sometimes if you wear a cross and your employees say no, you're not allowed to wear that, or if you wear a headscarf and they say you're not allowed to wear that, that is your right to religious being breached. Okay, so these are some examples that we have in this country. Okay. Previously, they were not able to rely directly on convention rights in the domestic courts. It also provides public authorities with a legal framework to help them to ensure that their actions respect the human rights of those for whom they provide services, which may prevent problems arising in the first place or enable a resolution without the need to go to court. There are 16 basic rights in the Human Rights Act, all taken from the European Convention on Human Rights. They do not only affect matters of life and death, like freedom from torture and killing, they also affect people's rights in everyday life, what they can say, what they can do, their beliefs, their right to a fair trial, and many other similar entitlements. So you have them rights and they're so important. An example is the next page, which is giving you, how does the human rights affect me? So public authorities have an obligation to act in accordance with the convention rights, and therefore public officials must understand human rights and take them into account in their day-to-day work. This is the case whether officials are delivering a service directly to the public or devising new policies or procedures. Understanding human rights can help in making the right decisions when it comes to decision making. The rights of one person often have to be balanced against the rights of others or against the needs of the broader community. But if you need to restrict somebody's rights, you must make sure that they are not using a sledgehammer to crack a nut. Any restriction must be no greater than is needed to achieve the objective. This is called proportionality. Example of its impact. Article 4 is the prohibition from slavery and forced labour. Everyone has the absolute right not to be treated as a slave or to be required to perform forced or compulsory labour, except for certain limited types of obligations specified in the article. For example, work in prison. What does that right mean? Everyone has an absolute right not to be held in slavery or servitude, to be required to perform forced or compulsory labour. The article states that there are 4 types of work that are not to be considered as forced or compulsory labour.
Okay.
Any work that forms part of civil, normal civil obligation. Any work under during legitimate detention or on conditional release from detention, prison work or community service. Anything that's compulsory military service or civilian service as a consciousness objector, and community service in a public emergency. Keywords and meanings. Slavery and servitude are closely connected, but slavery involves being owned by another person like a possession, while servitude usually involves a requirement to live on another person's property and no possibility of changing the situation. Forced or compulsory labour arises when a person is made to work or perform a service against their will, and where the requirement to do the work is unjust or oppressive, or the work itself involves avoidable hardship. It can cover all kinds of work and services. Is Article 4 relevant to my work? Article 4 will be relevant particularly if you suspect that someone is being forced to work without suitable recompense and under unjust conditions, have powers to make people work in an emergency, have powers to regulate employers in relation to things like working conditions and health and safety. 1D1, now this is for the distinction one, to analyse the tension between secondary legislation and the principle of separation of powers. Separation of powers is a constitutional principle introduced to ensure that the 3 major institutions of the state, namely the legislative, the executive and the judiciary, are not concentrated in one single body, whether in functions, personnel or powers. Legislative is a law-making body, executive puts the law into operation, and the judiciary interprets the law and settles disputes. What are the principles of separation of powers? The separation of powers is a representation for the governance of the state. Under this model, a state's government is divided into branches, each with separate independent powers and responsibilities, so that the powers of one branch are not in conflict with those of the other. The term separation of powers can be defined in the strict sense and the liberal sense. In the strict sense, separation of powers means that there should be a clear distinction of functions between the 3 organs of the state, and there should also be a check and balance between the 3 organs. So the reason they have a check and balance in place is that they don't want any sort of abuse of power from any of the 3 states, because it's really important that they have a separate function. There should not be an overlaps in functions, personnel and powers. In the liberal sense, separation of powers means there could be an overlaps in the functions and personnel between the 3 organs, but there should also be checks and balances between the 3 organs. To see how and whether separation of power is practiced, we would look at the relationship between first the executive and the legislature, secondly the legislature and the judiciary, and thirdly the executive and the judiciary in three countries, the UK. So the executive and the legislature. Now we're going to look at the relationship between each one. Okay.
Okay.
So the executive and the legislature. In the UK, the government personnel is provided by Parliament. The Prime Ministers and the Ministers of the Crown must be members of either House of Parliament. The powers of government are scrutinised by Parliament. However, there's some limitation to that under the House of Commons Disqualification Act 1975, which only allows certain people to hold the parliamentary office, and there's also limitation to the number of government ministers to the House of Commons. Despite that, the government will still have automatic support of 120 members of the Parliament. The operating period for the government depends on Parliament. We can also see the interference of the executive in Parliament through delegated legislation, as the legislative function is exercised by the executive and not the Parliament. A vote of no confidence against any government policy can be resulted in the downfall of the government. The opposition will oppose or support the government based on how they govern the country. Question time debates and select committees are parts of checks and balances which help to ensure the accountability of government to Parliament in any matters. Elections is a way which citizens can use to object or agree by voting. Now we're going to go on to the legislature and judiciary. So in UK, Parliament is not allowed to discuss certain issues if it has yet to be brought to the court for trial. Parliament also cannot criticise judges. However, since UK adopts parliamentary supremacy, Parliament has the powers to influence the judiciary. Parliaments can dismiss any court decision through legislation, and judiciary is supposed to interpret the legislations passed by the legislature. Judges are also said to play the function of the legislature by applying the doctrine of precedent and by interpreting statutes through statutory interpretations. Basically, judges gives meaning to the statutes passed by legislature, and the meaning given might not be what was intended in the first place. Therefore, judges also said to make law, and in cases where there's no law for certain areas, with such cases before them, judges would have to come to a reasonable new principle. So judges are there to interpret the law, not to change the law as it goes around, okay? So they are there as the main interprets the law in any cases or anything. Executive and judiciary. In the UK, the prerogative is part of the common law. Judges actually define the existence and scope of the prerogative. Apart from that, the law officers of the Crown, such as the Attorney General and the Solicitor General, are members of the government. The law officers' duty is to advise the government and ministers. Judicial review is a way that can be exercised by the courts to ensure that executive do not abuse their powers, and as means to uphold the rule of law. Judicial review by the courts as a way of checking an executive is also said to be a kind of overlap between judiciary and executive. The interference of the executive in judiciary can be seen in the powers of the executive to appoint judges. And now, in conclusion, the doctrine of separation of powers is only theoretically, and in reality is not really practiced.
Okay.
Judiciary should be independent and neutral to protect rights and liberties of people. There should not be any influence or pressures from other parties, but in this case, the executive appoints the judges. The executive, on the other hand, should not have so much power as to appoint judges that may be on their side. And the legislature should not have the power to make any law they like. This is to prevent the abuse of powers by the organs which affect the rights and liberties of citizens. In some cases, overlapping between the three organs is unavoidable. So sometimes, the three organs have to work together, but they must make sure there's no abuse of power. Do you think in regards to looking at this abuse of power and separation of powers, do you think sometimes there is abuse of power between these?
Definitely.
Yes. Yeah. Why do you think that?
I mean, so far as if you're working with human beings, this would definitely happen. But
there is. I agree with you, Jacqueline, that there is abuse of power. It's how they hide that abuse of power as well. Sometimes certain, people can hide it well compared to others. But it does happen in every country. There's a form of abuse of power.
Yeah, everywhere.
Yeah, it's true. It's everywhere. Yes. So some of the references are on the next page, which you can go to in regard when you have time. So we've got legislation.gov.uk, Parliament website, Equality, Human Rights, ICLR1, Law Teacher, and the Wikipedia. So you can go to these. And also, we've finished now. Have you got any questions?
So far, the only question I have is, you read that the common law rules, it says the common law rules precedes over the common law. That I didn't understand. What does it mean? If the common law rule precedes over.
So if something is for example, if the case is being passed through common law, must judges rely on that case? So judges, common law is very important in regards to, when we're making decisions in court. Why do you think it's so important?
It is important so that judges could refer to previous cases so they can apply.
It allows, obviously, it's common law is the system that was made up, and it was the system that adapted the law in situations, so it made the law more, it gave emphasis on precedent. So it was really important because it's so useful, because it looks at similar cases, and also it looks at identifying whether these cases, if judges need to, apply these cases in new cases. So any decision that was made in an old case, they are confident to apply that in any sort of new case or any sort of similar case.
Okay.
So anything that's decided in common law time, we can still rely on, and it could help us make a decision on a case. The common law is really important in that instance. It's always been really important, and it will be, and I think it will stay really important because we rely on it so much.
Okay.
So what I want you to do for next week, Jacqueline, is do these self-assessment questions. Can you see this for homework? And then we'll go through these at the start, so we've got an idea. Okay. Have you got any questions, Jacqueline?
I wanted to also know if there have been any reforms. I mean, could there be any reforms when it comes to the common laws?
No, the only reform would be the new laws that are being passed through any sort of delegated legislation.
Okay.
The common law, it will stay as it is because it's history.
Wow. Okay.
Yeah, common law is a historical element. It's not something that's new. It's historical, and common law is adopted historically a long time ago in regards to people using it. Then and that's how it's been adopted. So anything that's it originated quite far back in the reforms, like I mentioned, of King II, King Henry II in the 12th century.
Okay.
So it is used, and England and Wales actually operate on a common law system. We operate on that system through the creation of precedents and case law, and Parliament and the monarch. So it's quite a historical system that we still follow.
Okay, so what happens when there is a different case, like a complex case, that the common law, only the common law cannot solve, right?
So then it would be up to the law itself and the sense. If a judge had to sentence someone, they would refer to the sentencing guidelines. So if there was no cases that was there to help them, the judge has the discretion, obviously, to decide on a case himself. And then if there's no cases similar, there may be cases that are a little bit similar, but if there's no cases that are similar, then they have to follow the sentencing guidelines to sentence someone.
Okay. All right.
Okay.
All right.
Any other questions, Jacqueline?
No, that's all.
Thank you.
Thank you very much. I really enjoyed
the session. Thank you.
I really enjoyed the lesson.
Thank you. And I will see you next week, Jacqueline.
So
try and do these questions, and then we'll go through them, okay, next week.
All right. I'm looking forward to
it. Have a nice week. Have a nice bank holiday tomorrow.
You
okay?
too.
Take care.
Thank you very much.
Bye.
Bye. Thank you. Bye.
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 Bye.